I believe I need to announce that the session is being recorded. Is everything okay? Can we start? Everything's fine. We can move ahead. Hello, everybody. Hello. I'm going to host today's roundtable to the topic of public procurement. Some of you, we've had the honor and the pleasure to cooperate with some of you previously in our activities that were implemented within the Business Integrity Country Agenda project that Transparency Serbia is implemented together with Transparency International from Berlin, and according to their methodology, and supported by the EBRD. Here we have the publication, the study that we put together and published in November last year, and it can also be downloaded from our website. I'm going to ask my colleague Zlata to put the link in the chat box for those that haven't had the opportunity of familiarizing themselves with the findings of the study. Our idea, since it's been half a year from the publication of the survey and the presentation of its findings and recommendations, it's our idea to take this circle of people who have the knowledge and the wish to consider the issues of public procurement and go through what we've learned over the previous 6 months, both in terms of the issues in the implementation of the law or examples of good practice that should be disseminated so that the competition is higher in public procurement than it was before. We have people invited to this conference who made the advisory board of our survey. They come from a bevy of state institutions, educational institutions, economy as well. And we've invited members, our colleagues from NGOs, from the Chapter 5 working group, and representatives of public authorities, all of those that we perceived as possible contributors to improving the situation in this field. Some of them were able to heed our call, others weren't. However, whatever we point out today and whatever we conclude, anything that can lead to improving the system is going to be shared with others, and we are going to address those institutions whom we believe can make this change happen. The idea is for us to briefly present some of our viewpoints of the current situation in terms of competition in public procurement and related issues, and also to hear as much from you about what we've missed, where you see these issues, and where you see the possible solutions. So briefly, I spoke about this a moment ago at a conference that was open to the public. It was for the media. Somebody's got a microphone on. Can you please mute yourselves? Those of you who are not actively speaking, we don't need to have... We've seen some new and old issues related to public procurement that are impacting negative competition. So these are situations where the law is not being implemented, especially based bilateral agreements, and also the new law has drastically increased the thresholds that the public procurement must be implemented under. It's not 500,000 dinars, it's a million, 15 or 15 million dinars. And also we have something that disturbs the complete insight into public procurement. It is the situation that the public call documentation is not being publicized, and also the fact that currently public procurements must be published on the portal and not on the websites of the investors. That is a deterioration in terms of the previous law, because some bidders could get their information from the websites of the competent authorities ordering public procurement, and the public has been denied access to this effectively. We've had some public procurements that are still being implemented by limiting competition unfoundedly through discriminatory conditions stipulated in the public call documentation, and also the oversight of the implementation of the law is not sufficient, and the number of cases for which we can see from the Public Procurement Office, it was 35 last year. In terms of reports of the public bodies, it was 42, and for many initiatives, reports against certain public procurement investigation, we don't have data of how many there were. Transparency International has sent numerous initiatives to the Public Procurement Office, and none of them were listed in their yearly reports, so we don't even know how many initiatives happened and how many situations happened that were potentially debatable or disputable. We saw as one of the opportunities to improve the situation, because the public procurement law is going to be amended, and we would like to invite the amendments to be broader in scope. We don't want to limit them on just media services, because there's obviously a need for those, and we've seen many opportunities for competition to be enhanced through other methods with no amendments to the law. And the first topic that I would like to put forward, and I would like to really hear your opinion on before you present your suggestions or viewpoints of the shortcomings of the system, is the following. We have currently we have a situation that there is an obligation for the economic operators who want to take part in public procurement procedures must be registered in two places. They need to be registered in the public procurement portal, and they need to be registered in the business registry agency. It's fine. That can be helpful. However, what we believe is that the scope of data which is listed when making these registrations need to include also what the economic operators can offer through public procurements. What are the types of services or goods or works that they can offer, and that can all be recorded through the reference numbers from the master data for public procurement. So our opinion is that the client should be obligated to include all of the companies that can provide certain services or goods or works, needs to invite all of these companies to bid. All of these companies can be individually informed, and we can try to increase competitiveness in public procurements in this way, because public procurement has never seen more than 3 bids for each procurement, and in many cases we can witness that we have only one bidder, whether it's because the public call documentation was intentionally developed to exclude any other bidders, and maybe there were some illicit agreements between the bidders, or due to the short time span for bidders to come forth. I would like to hear your opinions to this, and so we can see if you think the idea is good, to see how we can elaborate it and make it happen. Please, you can raise your hand or just switch on your microphone if you want to offer a comment. Does this mean we have general consensus? I really want to know if our colleagues from the Chamber of Commerce have an idea about such an initiative. Could this be good, or do you believe, or other representatives of the industry, do you believe this would lead to higher competition in public procurement procedures? I have a question. Yes? I'm going to go back to the sociological narrative from a while back. I had an opportunity of working on an analysis in Macedonia around the integrity of public procurement there. And their plan... Can you hear me? Yes, yes. Please go on, Zoran. Everything is fine. They provided for an integrity plan for public procurements, and it's very relevant around this model to have integrity in our country. They're going to work on the gentleman's audio is really snippy. The integrity plans, the mechanisms that include various institutions without bidders, citizens, without the professional community, and without transparency and publicity. So two crucial issues are planning and execution, and they're not covered. What you talked about in terms of the law, I believe it's very important to find mechanisms for citizens and the professionals to be included and consulted, and I believe that is the way for the citizens to feel the benefits of getting involved in public procurement processes. Another thing for the civil society, monitoring the public procurements. I'm sorry, the audio is really choppy and I'm having trouble. Third thing, I believe the Public Procurement Office needs to come out with a strategy or a tool for communication. We are people who... directors and institution leaders. I don't know who is the head of the Public Procurement Office, and that really speaks about its visibility and its involvement with the engagement with the public. So, apart from the institutional action, it's very important that the public, as a participant, needs to be somebody to monitor or be consulted about public procurements, and I believe that is how we can increase the quality of the public procurements. And I believe we cannot have public procurements in a country where we have a lack of rule of law and struggles with the market economy. I believe that should be kept in mind. The fact that we have the three bids principle, that can be the fruit of the fact that we don't have a developed economy, and our market economy and market rule or market mechanisms as regulating the economic field are still not sufficiently developed. And that is ultimately manifested in terms of the public procurements. Thank you, Zoran, for being the icebreaker, and thank you for your comments. Your audio was a bit choppy, and we mostly heard what you said. Of course, increasing the public interest is something that ultimately should contribute to increasing competition. The example from Macedonia that you gave is the integrity agreements, I believe, not integrity plans that we do have in our law. Did I understand you correctly? Your audio was really choppy. They plan to have
with
this
act,
new
that the government
regulation.
adopted, they plan on having integrity plans. Okay. Well, there is integrity plan is in our laws. You are speaking about the concept that's different somewhat, that the yes, in principle, yes. This is a concept that will be different than in our country. It's more holistic. That's a holistic approach compared to ours. Here, for example, I'm sorry, the sound is very poor, so it's very difficult to translate because every second word is is inaudible. Okay, so I have a comment in relation to something else you said, speaking about one of the reasons for poor competition is maybe the fact that the market is underdeveloped. This is the case in certain situations, but not in all. For example, I recently had the opportunity to comment on a very large procurement by the tax administration, where only one company applied, a consortium of companies related to the implementation of the IT system. So we can say, well, there are not many companies involved, but other companies that got similar deals just didn't apply. Not a single international company applied. Because if we can assume that outside of Serbia, there are also companies involved in these affairs, and we know there are. So the client left only 20 days for preparing a bid. For these 20 days, well, it was difficult to examine in detail a very complicated competition documentation. And there we can see not only that perhaps the market is underdeveloped, is that the clients are not doing what they can in order to provide for as many applicants as possible applying on the bid. Do we have any comments?
Nemanja, ja sam htela da se javim. Ako mogu, nisam našla gde da podignem ruku. Ja sam htela prosto da ne oduzimam puno vremena. Aleksandra Sekulović, ja sam iz Naleda, inače sam projektni menadžer na projektu efektivne javne nabavke za ekonomski razvoj koji sprovodimo sa Švedskom agencijom za međunarodnu saradnju sa SID-om. I ne bih nešto puno vremena oduzimala, prosto samo ću reći neke stvari na čemu smo i mi počeli da radimo, a između ostalog to je da pokušavamo da napravimo unapređenje tog registra ponuđača, da napravimo i bolje performanse i prosto da bude povezano sa drugim bazama. A isto tako bismo na osnovu ovog što ste vi rekli, Nemanja, na početku, podatke o ponuđačima i sve to. Nekako ideja nam je bila da u tom registru mogu da se nađu i svi ostali podaci. Znači, ako neko nije dobro izvršio ugovor, koliko je imao između nekih uspešnih ugovora, ukoliko nije dobro prosto radio neke stvari u smislu ne samo izvršenja ugovora, nego prosto ako nije relevantan ponuđač. Tako da to nemamo nekako, nemamo odgovor od nadležnih organa niti od APR-a da bi oni to hteli da urade i da negde mogu na jednom mestu da se nađu te informacije koje su svakome relevantne. Znači, prosto da zna sa kim ima posla i da sami ponuđači mogu da nađu više informacija i o javnim nabavkama i o konkursima i o svemu ostalom. Eto, tu bi bilo dobro da imamo neki konsenzus i kako to rešiti i gde mogu da se nađu te podaci. Ne moraju samo negativne reference. Mislim, dovoljno da postoje i samo prosto ono što jeste činjenica. A to je na koliko konkursa je učestvovao, koliko je dobio, prosto poslova, da li su ti poslovi izvršeni do kraja. Znači, prosto to su činjenice. Tako da, eto, a nemamo nekako rešenje još uvek kako to da regulišemo i gde da se nađu svi ti podaci. Ja sam samo toliko htela, pa možda ćemo nekako i zajednički u tom čitavom dijalogu da imamo nekakva rešenja gde i mi možemo u projektu da se angažujemo i da predložimo nešto.
And for us to support and propose something in the project. Thank you, Alexandra. This proposal is in line, actually, with what I said in introduction. What we should perhaps try to address this whole thing not through the business register agency, which, keeps the records that it has, data from other databases of theirs, but to try to regulate this so for this data to be available on the portal. Among the information collected currently by the Office for Public Procurement. But there are ideas to move this somewhere else. Of course, data can be stored in several places, and by getting them through the portal and by publishing the information as to not only how many tenders someone was involved in, but also what was the satisfaction with the realization of a certain transaction, a certain deal, that all this would be very useful. Mr. Miletic said that in the application for the competition, there is a reference list. By that, you mean information sent for the specific procedure when the bidder proves their eligibility for... Milicevic, not Miletic, sorry. I have to change my glasses. Yes, the professor is right, but it seems to me that this is not the case with all procurements, but only those where the client has put as a prerequisite for participating in the public procurement procedure previous experience or prior experience. And it seems to me that these are the conditions that are set. I want to add, as for these reference lists, on these lists you put what's positive for you. You are not obligated to put something that that's not favorable. So you are choosing. You can choose 2 or 3 procedures where you have some references and to have 10 without, them being correct. So let's think positively as to how to have the clients invite more companies. Of course, they can be encouraged by seeing that someone has prior experience, if they will find data that the given contract was respected. And this is something that should also be found within the portal of public procurement, where there is a column for contracts, and well, another item can be used. If there is will, of course, I'm not speaking about cases that the client wants to restrict competition, because they can always find a way. But if they want, if the procurement was fair from the start, I think that we should think how to increase the number of companies, and maybe publishing the positive references of a central portal could be a good way for that. Do we have a comment? Well, perhaps I have one. Please, Jasmina Marcus, on behalf of the Association of Bidders of Serbia. As an association, we had many situations where we analyzed the public procurement, starting from the old law, which is not applicable anymore, but this institution was scrapped and we have the new law. But I can say something about our experiences. I don't believe that there was no will to implement this institute in practice, because when we used to forward our reports to the public procurement office back then, everything that we said that was negative, we never received a single commentary. I think that there should be more synergy between the authorities for controlling public procurement procedures, and this to be said publicly, that someone who was in non-compliance with the public procurement, they should be punished for it. I agree with Nemanja that we had the problem that very often the office, we told the office that a certain procurement is not legal. We had one case, maybe in 2018, I think, that the office really, well, responded and reacted. But it would be good for this to be the rule, because this is the way that the bidders would be encouraged to continue to participate in public procedures, public procurement, because they know that they are protected from abuse. As for the Republic Commission, what we have under the new law, and I think is a major problem in public procurement, is the fact that there is still the view that the client has the right to buy whatever they want in public procurement, that the technical characteristics of certain goods are chosen against their needs. So this is the position of the Republic Commission, that the ordering party, meaning the client, they have the right to procure what corresponds to their needs. It's a thin line, of course, between what corresponds to their needs and the elements that discriminate against the suppliers, because you have suppliers that offer better quality and good quality for less money. And again, they cannot, because we know that the client, well, has the right to choose what they want. I think that the Republic Commission should to analyze better these requests, especially in the cases where the technical specification of the records is being contested. And I think that before they had the possibility of hiring experts for a given domain, which will analyze whether the procedure is okay or not. But I think that it has never been the case, that the Public Commission has hired a technical expert. As for the state auditing agency, this was the only institution that, well, controls the PP procedure, and their reports were public and they were good. Until the moment when the reports started to become recommendations. Lately, whenever I read the report, you have recommendations what the client should remedy, should rectify. Well, recommendations are okay, but it seemed to me that before they were more far stronger. Well, again, it seems to me that in this case, the state auditing institution is the only institution that does its job correctly. When it comes to your proposal, I know that on the new portal, there is an option then that when the bidders can check the area, check the data for the area that's of interest for them, when they put an asterisk on the procurement on the website, they are informed that the public procurement is actually advertised. But how to encourage the suppliers to participate? As soon as they see the conditions, well, they just give up. Sorry, just what the bidders check or suppliers, whatever you call them, this is a possibility that exists when it comes to a very specific procedure. They're informed about it, or the possibility to pre-check a certain code. This is what I think we did. No, not the code. They have the possibility before a procurement is called to find a planned procurement on the portal and then to put an asterisk and then updates come to them. Let's imagine that someone has a printing company and they want, according to public procurement plans, to see potential clients. Well, this would make no sense. This would be too extensive. So when the clients, so whenever a printing company is registered and they check for a code for its services, they should get all the updates about all procurements that are called under this code. Like that, or for the clients search on their own who has registered and then to send direct offers. But this is very difficult. It's not feasible in practice. But automatic registration would be relatively good. When it comes to negative references, I agree with Alexander. On the portal, there should be a search concerning whether the bidder has, well, performed the contract well. It should be regulated by a bylaw, of course. It should not be left at the discretion of the bidder, etc. This should be grounds for termination of contracts or a legal procedure, etc., etc.
I have a request for clarification. What you said that the clients order what they need themselves, it's going to remain the same. Can you maybe give us an example of a situation which was disputable, according to your view, where the public call documentation cannot be disputed? Yeah, recently, because what is discriminatory provision that can be disputed? I can give you a million examples for that, but I know that in many examples, I wanted to put that forward as the next item. Why are procurements not being disputed? But I could use an example here to understand what we're talking about. Well, the specific example recently was that for traffic signs being procured, it was a client who wanted these traffic signs to be delivered from sheet metal, and other bidders could offer from these signs made from aluminum. That was the problem, because the material that the sign was made of is irrelevant. I don't know if it's relevant for anybody, but the sign is the same. It's painted on. And the decision from the National Commission was that the client has the right to specify the product as whatever they'd like. If somebody can offer a comparable or even better sign for less money, why would it be important to have these details involved? There should be a borderline between what is actually needed and what is a limiting provision. Yeah, this is a very interesting example. On the one hand, the client really should know what they want and what they need. However, on the other hand, maybe it was unintentional, but maybe it was intentional. They excluded the possibility of getting a better product, if I understand correctly. I understand that it is justified to ask for galvanized sheet metal because they have protection against corrosion, but aluminum may have even better protection. Yes, yes. Yes, excellent. This is actually a problem that you are correct. In the current legal framework, it's a big issue if it can be resolved. However, on the other hand, there are some more obvious examples where the public call documentation was rigged, like procuring cars and listing the paint job of the shade that only one company can provide. There is no particular need for that specific shade to be procured, or procurements are being tailored in other ways that fit the specification of only one bidder. And on the other hand, here's where we reach the issue. The Public Procurement's office is not acting frequently enough investigating these cases, and the competitors are not coming forward to dispute this bidding documentation, and there becomes a reason of what is the cause. Is it maybe that the fees are really high, that they may not have any benefit if they dispute the procurement, or is there another thing, or is it just a division of the market between bidders and then they do not argue against things that are obviously wrong at first glance? Does anybody else have any comments or ideas? Professor Milicevic, please take the floor. I'm sorry, I made a mistake a while ago. Yes, I have this problem with the idea that the client can offer whatever they want. If the situation is as it is, we don't have any fight against corruption here. The client has an obligation to order what is in the best interest of what they're ordering. And then I have to ask the question, what do the procurement or the public procurements entail? We have bidders, for example. Everybody who comes to a public procurement procedure knows that sometimes the bidders are fictitious, and that's why references are required. And the other thing that I'm talking about, there's a company that is developing very sophisticated software, and what are they doing? They're not developing this software themselves. What are they doing? They're offering subcontractors. One of the crucial elements in fighting public procurements is how weighing is made of the criteria. That's the much more complex issues than the issue of the client having the right to order whatever they like, because these are public funds. I don't see how they can have these rights. Yes, Professor, maybe I misspoke. I apologize. Of course, they shouldn't order whatever they like, but only what they need and what will satisfy these needs in the best possible way. I understand. It was more of a reflection on the law. And what would maybe help even more is, but there's another possibility here. Here we need to take it a step even further before for the purpose of public procurement plans. What is planned for procurement at which time? And then we come to the issue of creating budgets. how much, when the budgets are made, how clear it is what is going to be procured throughout the budget year. And these are the stages where citizens don't have enough opportunities to impact for the time being. And Yasmina, another thing occurred to me now. How much can you see the situation where the contract has not been concluded, even though the procurement has been concluded? I heard many examples from you that the procedure would go through and then the client would not conclude the contract if they don't like the bidder with the best offer. Do we have that still? Yes. Well, first of all, I hope that the new law will remove that possibility, because under the law now, the client has an obligation to send the agreement for signing 8 days after the validity of the decision. So that's being implemented, yes. But under the law that is not being enforced now, that was a major problem. Now we have another situation that clients have started to terminate proceedings when they don't get bidders that they like. For example, they say they find a mistake in the bidding documentation, that they didn't describe something as they should, and then they cancel the procedure, they terminate it to supposedly remove this mistake that was noted. And so that's a new tactic. And of course, there's no appealing this decision. There's no request to safeguard rights. If you submit a claim, you cannot get anything, because the client has the right to terminate the proceedings if they've made a mistake and if they mistakenly made the procurement for something that they don't actually need. Great. All right. Do we have some good experiences? Has something started working better than it was before? Apart from this problem that we solved. May I say what? Yeah. Share your experiences, please. A good thing, an excellent thing is the portal. Electronic bidding is something that is the best thing possible. Also, the procedure is shorter in terms that you are not sending evidence. The best bidder is required to send evidence, and the procedure of bidding, for those who know the work on the portal, it is a bit of a problem for people who are first comers, but the procedure is the best possible development. I truly hope that more people will apply now, because it's much easier than it was before. There's much less formalism. No, but more people are not coming. They're not bidding than they were before. It's the same statistics. I don't know. Yeah, the statistics are the same. There's no improvement. There's maybe a symbolic improvement in 2020 compared to 2019. I don't know if the situation is that the majority of the public procurements have been taken out because they are under the threshold for initiating a public procurement procedure. Do you have these experiences for these procurements that are under 1 million or 3 million works? Do any of the bidders even try to get, do any of the clients even try to get larger number of bids, or are they actually just not publishing things that the legislator does not stipulate? We had some experiences with some municipalities. I know that some municipalities have adopted some internal acts where they provided that they will initiate procedures, public procurement procedures for values that are under the threshold. I believe that could be one of the ways to overcome these issues, that the raising the threshold is created when there are no legal obligations. Because we had a suggestion about this. I saw that Sanja Stankovic from OSCE logged in. We had a suggestion about the media services, and the amendments of the law that I mentioned at the beginning needs to be made, and for these procurements, the threshold needs to be brought down, at least to the level that we had in the old law, and more competition can be provided in this way, at least for media services. And of course, we are going to see if there's will and reasoning for others to follow suit as well. All right, are there more comments, other experiences that we may have missed? Something that you think that we should consider when we address state institutions with joint issues questions? Do you have any other suggestions that can improve transparency and competitiveness in public procurements?
I think that the Public Procurement Office should introduce a bylaw subject to the law to put this in some kind of legal framework, because the thresholds are too high, and the procurement below the threshold should be more visible, at least to publish the call on their website. Yes, we have a problem with this. I think that, well, when the law was being adopted, we tried for the law to retain the obligation from the law from 2012, obligation for the Public Procurement Office, namely to make a bylaw and to make a model of the internal act on the application of public procurement, implementation, sorry. And this internal act, well, inside by that you can prescribe a rule as to how to have the public nature of public procurement below the legal threshold. This would, for example, be one of the ways, one of the modalities as to how to deal with this. We had, let me see in the chat. I think that Professor Milicevic had a comment. Let me see. So will the records be, well, sorry, the question was related to the case invoked by Yasmina when the procedure is suspended. Professor, do you hear me? I'm not, this question is not clear. Or... I'm here. There are many ways to insert certain clauses when things are forgotten, when things are insufficiently defined. These can be grounds for a public procurement is suspended. So my question is, if something is omitted, should we ask for the completion of documentation, or cancel the procurement and or change it by, well, having another company get it? So this has all been seen in practice. I guess that you haven't received an answer by the government to your report concerning public procurement. That it was the same case as in the case of other reports. Yes, but we didn't get, when we asked to see for large procurement, to see the plan of procurement, we didn't get anything. You mean plans? If you are planning on having a procurement, substantial procurement are planned. Often they have deadlines and they must be anticipated and provided for. Yes, the plans must be published at the beginning of the year. Yes, but have they been published? Probably not all. But what we've seen is that more often than not, the estimated value is omitted. Well, for the reasons of, well, they say secrecy, although this is highly suspicious. Yes, the insider trading and secrecy is clearly defined in public procurement. This is one of the weak points of, because these data often leak. Another problem is when you have a deadline to procure something and when you know that this must be announced a year in advance. If you prepare, if you inform a company, they will be the only bidder. And then you impose the deadline for documentation a month, and then one company will, and only one company will be prepared. I'm speaking about things that happened. It's quite clear. Nemanja. Thank you. As far as I understand, this is a debate which in any case will contribute to resolving delicate problems and issues that exist everywhere in all countries. And in the anti-corruption projects that we are working on in the Chamber of Commerce with several European institutions, not only about Serbia, but the whole region, we mentioned this as a huge major issue. I'm not sure if I'm going to be specific, but I wanted to point to several things, because among other things here, Mr. Gavrilovic, well, he had the best intentions. He mentioned that the Chamber of Commerce could keep a list, a white and black list, as he said, of organizations, companies participating in public procurement. Currently, I couldn't speak about that because within our systems we have, among other things, Miss Maria Markovic, which attended this webinar and which is the most qualified to make a contribution when it comes to this topic. But among other things, since last year, well, it was interesting from the standpoint of the pandemic, state of emergency, procurement of medical drugs and equipment. I'm not sure if anything changed, but this principle could apply to different areas, many different areas. I think that Yasmina mentioned it when she spoke about traffic signs. I'm not sure if in other areas this exists, but I remember that several years ago, when procuring medical equipment, a small health center in the health system, they could procure an X-ray machine of better quality than the clinical center of Serbia. I don't know if things changed in the meantime, and if any bylaw was adopted, and I think that this is something that perhaps could, well, arise as one of our proposals, and this is that in certain laws to have bylaws adopted about the technical specification for procuring certain equipment, mostly fixed assets, for example, or basic equipment. Then we would not have a dilemma whether traffic signs of tin or aluminum should be purchased finally. And after all, there is always many exceptions, and this is that in the framework of clear technical specifications for certain in the case of procurement, if someone offers better quality material without the price difference, this could be considered as an urgent criteria in order for that party to be awarded the deal. You mentioned integrity plans, especially those in Macedonia. Sincerely, I'm interested by this piece of information because the integrity plan is one of my professional, areas. In the Serbian Chamber of Commerce, we make preparations for starting the activities on the new code of ethics. We compared the best and analyzed the best examples of codes of ethics. All of them, almost all of them, mention public procurement and the attitude of the organization adopting the code of ethics towards public procurement as one of its elements. This is not something that could be some kind of considered an artificial statement about public procurement. Simply, this is something that's binding in a way, because based on violations of rules from the code of ethics, there can be disputes, or in this way, by respecting a code of ethics, you can see to what extent an organization is exposed to corruption or not. So these are some of the issues I wanted to mention. Here in the chat, we can see there are certain mechanisms from the Serbian project of Chamber of Commerce projects, an anti-corruption project, among others, with Romania and Italy, which establish certain mechanisms for auto-regulation, self-regulation. You have questionnaires on the website of our Chamber of Commerce. These questionnaires give the possibility to SMEs to make their own due diligence when it comes to exposure to corruption. This is one of the ways how the Chamber of Commerce, within its basic mission, educating the members, influencing the members, so as for them to adhere to certain rules of compliance in the holistic way. So these are things that not only we have worked on, but we have been working on, not only when it comes to Serbia, but also the region, because the Chamber of Commerce of the region of the Western Balkans have similar missions and visions and activities in this part, and we are working together on all this. Thank you. Thank you, Miroslav. We have something that I want to mention. Of course, while understanding the role of the Serbian Chamber of Commerce, I'm sure we can work of something that's in the interest of Serbian businesses to get more public procurements in an open and fair proceedings. I have a comment in relation to something that Yasmina said about hiring experts. One of the recommendations that we have put in the survey about business integrity, and this was proposed by the representative of the U.S. Chamber of Commerce, people should be educated, people which are the decision makers about public procurement in state institutions, so that they can know whether something is a legitimate grounds for setting the proper conditions for the client and what is discrimination. What technical specification is legitimate and what is not. And your proposal, well, is great. Generally speaking, I have a comment. Yes, everything that's we will conclude, and on our prior conclusions about what can be beneficial, this can be packed, so to speak, in a document that Serbia must make based on the action plan for chapter 23. This chapter, you know what we are talking about if you read it. In many parts, it is unclear, lacks precision. And among other things, currently, the plan does not include the making of a new national strategy for fighting corruption. But what is part of the action plan is the drafting of so-called operational plans. 8 areas are mentioned in relation to which operational plans should be made. One of these 8 areas are public procurement. Other areas are privatization, taxes, healthcare, education, local government. I probably forgot someone. Things are quite strange. The Ministry of Justice has inviting NGOs to respond and participate in the making of the operational plan. They put only 5 of the 8 areas, including public procurement, and we applied. So we do participate in this working group. The activities are at their beginning, but some state institutions are also included, among others, the Public Procurement Office. Of course, I believe that the Anti-Corruption Council should join also. I don't know if the invitation came at all to the Chamber of Commerce. Are you included in a way or not? But this is an obligation that exists in the action plan, and it wouldn't be good if this opportunity is missed to integrate there some of the main issues that should be remedied in this area. We will use the possibility to suggest to the working group, and we'll put all the proposals we mentioned today in order to increase competition and curb corruption and other deficiencies. Do you have any other ideas when we have this framework that we can use?
If not, going once, going twice, going thrice. All right, I would like to thank everybody, especially those who actively took part in the discussion today. We're going to take minutes and we will send them to all of you. And if you have any specific ideas around what can be improved in this area and the suggestions that we should take for the operating plan and to the Public Procurement Office, please send them as soon as possible, because we'll go forward with these initiatives as early as this week. Thank you all once again, and see you next time live, hopefully. The weather's going to be better. So the end of coronavirus is going to be also announced to be soon. Bye, everybody.
Smo uspeli da napravimo spisak neki?